Ready whenever you're set.
Yes, sir.
Ryan Michael Wallace.
All right, Mr. Wallace, give me a moment here. Okay, we're here for a few reasons. We're gonna start with case number 2025 TR 12164. There was a warrant for your arrest for failure to appear on a driving suspended violations with our court. What I'd like to do is have that appearance now to save you another trip back to court. Is that okay with you?
Yes, sir.
Specifically, what I'm asking for is permission to hold this hearing by video instead of having you stand in front of me and personally appear on a different date. Do I have your permission to waive your personal appearance?
Yes, sir.
All right. The driving suspended violation is a class 1 misdemeanor that's punishable with a maximum fine of $2,500, 6 months of jail, and or 3 years of probation. There is no jail time requested by the state, so you're not facing that as part of the consequences. Your options are to plead guilty, not guilty, or no contest. If you plead guilty or no contest today, then we'll move forward into sentencing and conclude the case. If you plead not guilty, we'll schedule you for a pre-trial conference. That's where you meet with the prosecutor, have a discussion with them, and one of the following results will occur at the conclusion of that. Number 1, the case could go to a trial. Number 2, the case could enter a plea agreement. Number 3, the case could dismiss. Or number 4, you could change your plea from not guilty back to guilty or no contest if you chose to. Or it could be continued. Do you understand that?
Yes, sir.
All right. You also have the right to an attorney. Your choices are to hire an attorney at your own expense, to waive the presence of an attorney, or ask the court for a court-appointed attorney. To have a court-appointed attorney, there are 2 requirements. Both must be met. Number 1, you must not be able to afford an attorney, so we would send a financial questionnaire you would complete, and if you financially qualified, then that's one of the 2 requirements. The second requirement is that you must have good cause. An example of that would be is if there was loss of liberty or jail time, but since I've informed you there's not jail time, if that changes, so does your rights, and you could have a court-appointed attorney if that changes. Do you understand that?
Yes, sir.
Okay, regarding the attorney, do you wish to waive the presence of an attorney, hire one at your own expense, or ask the court for court-appointed?
I don't need an attorney.
Okay, so I'm going to be sending you a waiver form that waives 2 things. Number 1 is your personal presence that we talked about, and number 2, the attorney portion of the case. All right. Your options are to plead guilty, not guilty, or no contest. Guilty plea means that I admitted I committed the violation. Not guilty means that you're denying you committed the violation or that you wish to speak with the prosecutor. And no contest is I'm not admitting or denying, but I'm accepting a conviction. Both guilty and no contest show on your criminal history as a conviction. Do you understand that?
Yes, sir.
Do you have any questions before I take a plea from you on the charge?
No.
How do you wish to plead?
Guilty.
Okay. I'll enter your guilty plea. I want to now inform you of the rights that you're giving up with a guilty plea. By entering your guilty plea, you're giving up the following rights. The right to plead not guilty and require the state to prove your guilt beyond a reasonable doubt. You're giving up the right to have the assistance of an attorney at all stages of the proceeding, including appeal, and that's what we talked about with the waiver form. You're giving up the right to confront witnesses against you and cross-examine them as to the truthfulness of their testimony. You're giving up the right to have a trial in front of a judge. You're giving up the right to present evidence in your own behalf and have the court compel your chosen witnesses to appear and testify free of charge. You're giving up the right to remain silent and to be presumed innocent until proven guilty beyond a reasonable doubt. And you're also giving up the right to a direct appeal. Are you on probation or parole?
No, sir.
Okay. Let me just catch up a little bit of the paperwork. All right, I want to make you aware of possible collateral consequences, and those include the following: the possible suspension of your driver's license, an impact on a commercial driver's license or other professional license, an impact on insurance rates, the revocation of probation or parole, an increased penalty for further criminal charges, becoming a prohibited possessor if convicted of domestic violence charges, and if you're not a citizen of the United States, a plea or finding of guilt may result in your deportation or being denied citizenship or reentry. Further on citizenship as an advisory, Rule 17.2, if you're not a citizen of the United States, pleading guilty or no contest to a crime may affect your immigration status. Admitting guilt may result in deportation even if the charge is later dismissed. Your plea or admission of guilt could result in your deportation or removal, could prevent you from ever being able to get legal status in the United States, or could prevent you from becoming a United States citizen. Understanding each of these rights I've just explained to you, wish to waive those rights and enter your guilty plea?
Yes, sir.
Okay. Factual basis of your case is that on December 23rd of 2025 at about 4:16 p.m. you were contacted at Highway 260 and University Way, milepost 253.8. That's in Payson city limits in Gila County in the jurisdiction of this court. It was found that you were operating a motor vehicle on a public roadway. Why your license was suspended, revoked, or canceled, and you are here pleading guilty to that charge today. Does that sound correct?
Yes, sir.
All right, regarding your guilty plea, are you making that voluntarily?
Yes.
Nobody forced, threatened, or harassed you to make that plea?
No.
Did anybody promise you any lighter sentence or punishment that if you pled guilty, you'd receive it?
No.
Court finds that you entered your plea of guilty knowingly, voluntarily, and intelligently and will accept your plea. I'm going to give you a letter that talks about how you can file a Rule 33 petition for post-conviction relief, and if denied, file a petition for review. It'll also inform you how to set aside the judgment of conviction pursuant to Arizona Revised Statutes 13905 once the terms of the sentence have been completed, and you may qualify for a certificate of second chance, and you may apply to seal the records pursuant to Arizona Revised Statutes 13911 once the terms of the sentence and the timeframes therein have been satisfied. So that letter will explain each of those portions to you. You're going to
Okay.
see a form that has my initials down the left column. Those are the rights that I just reviewed with you that you're waiving by entering a guilty plea. So you'll have to sign where I've indicated on that form. Do you wish to give a statement to the court before I impose sentencing?
No, it's okay.
Okay. Are you employed now?
Yes, sir. Well, I'm self-employed.
Okay. Okay. The court's going to impose a fine of $500 for the violation. Are you currently making payments to the court?
Yes, I am.
Are you on time with your payments?
I'm late right now.
Okay.
I think I'm a month behind.
Okay. I'm going to just indicate on here to continue to make your monthly payments.
Okay.
How many times have you been arrested for driving on a suspended, revoked, or canceled driver's license?
I'm not sure.
Okay, roughly.
There's been a few times.
Okay. If there's another incident, I can't promise you that there won't be more harsher consequences that are going to be presented by me, the court, or me or another judge. Can't
Okay.
just keep having you do repeated offenses and the fines continue to go up and the fines continue not to get paid. So I'm just trying to give you a little heads up on that.
All right, I understand.
I have to assign a $20 payment plan fee since it can't be paid today. So the total balance that's owed to the court will be $520.
Okay.
You'll have to find, this is called the sentencing and judgment form. That'll require your signature as well. And then I'm giving you the notice of warning and rights. That talks about how to seal the cases and all of that. So that takes care of that case. So we're done with that. Okay.
Okay.
Additionally, there is a warrant for your arrest out of the Gila County Superior Court. And that has a secured appearance bond of $2,500. So you're going to remain in custody. I'm releasing you on the driving suspended charge, but you'll remain in custody regarding the bond for the Superior Court only. Okay.
Okay.
Now we'll go to the local charges. First off, let me confirm information here. The new charges are two violations. Both of them are felony allegations, and they're aggravated domestic violence. The first count is for a trespassing in the first degree. The second count is for disorderly conduct. You have the right to remain silent, right to counsel, and right to trial. I've scheduled you for a preliminary hearing on the 24th of July at 4 o'clock p.m. The preliminary hearing is to determine if there is probable cause to charge you with those two felony allegations, not convict you. If probable cause is found, your case will bind over to the Gila County Superior Court. If probable cause is not found, then those two charges could dismiss or be reduced to misdemeanor violations. There's also a possibility that the case will go in front of a grand jury prior to that court date. So the best thing for you to do is to inquire the business day before that court date to see if it's still proceeding. Your release conditions are obey all orders of the court, do not commit any crimes, notify the court immediately if your address changes, do not leave the state of Arizona without permission of the court, do not contact the alleged victim in any manner, and do not go near the location of the alleged offense. Do not possess or consume any alcohol or drugs without a valid prescription, and do not possess any firearms, since these are felony allegations, and if you're convicted, you could become a prohibited possessor. Do you understand those release conditions?
Yes, sir.
Okay, I'm placing a $5,000 bond hold on you, so you'll remain in custody on that charge. Being that you're remaining in custody, you have the right to a court-appointed attorney if you cannot afford to hire one. I'll be sending a financial questionnaire with your paperwork, so if you wish to exercise your right for a court-appointed attorney, complete that questionnaire. What also happens is the prosecutor must file a complaint within 48 hours of the date and time of this hearing. If they fail to file that complaint, then you do not have to post bond on that. You'll be released on your own recognizance. They still can file the case up to the statute of limitations, roughly near 7 years of the date of your arrest, when they want to file the case. If they do file the complaint timely and you do qualify for a court-appointed attorney, that's when they'll be assigned and they'll be made aware of your in-custody status, made aware of your charges, and they'll be in touch with you shortly thereafter. Do you have any questions on that?
Yeah, if I'm not guilty on this, how am I still being held on it? I don't understand how I can't have my say in it. I didn't do anything.
Okay, so the allegations, these are allegations, and what court has to do is determine if there's just simple probable cause to show that they occurred. And all I do is take the statement that is provided to the court, being that these charges are aggravated domestic violence, those pose a risk, so that's why there's a bond. You'll have definitely, it doesn't mean you're convicted of it at all. You'll definitely have an opportunity. Now's not the time to provide a defense or any reasoning. I would hold you from doing that to help protect your rights. This is just an informative position, and a release conditions are set. So you'll have that opportunity to plead not guilty and to proceed on with the court proceedings at a later time. But right now, there's the bond, and then the next determination is that probable cause hearing that I told you about. It'll either be done by grand jury, or we'll see you on that court date to see if there's probable cause. So that's what that's for. Does that answer your question?
When's the next court date?
It's scheduled for the 24th of July, so it's in 10 days. And it may go in front of a grand jury prior to that, and they make a determination. If it does not, we may see you on that date. Okay, any questions on that?
No.
All right, let me make sure that that was all the, yep, that's all I have for you then.
All right.
Okay.
Step to the counter, state your full name for the judge, including.
My name is Coleman Martin Villa.
All right, sir, you still live on Harmony?
Yes, sir.
All right. All right, you're held simply for a warrant out of the Sholo JP Court number 5, and that is regarding case TR 2023-236 in their court. There's a bond of $1,595. That's cash only. So if you post that bond, you'll have to be required to show up for court within 10 days of you posting the bond. If you do not post bond, they're going to be notified to come and pick you up to face whatever they need to talk to you about.
Okay. Well, I don't have the money to post bonds.
Okay, so they'll just be notified, and they'll be here in a reasonable amount of time to have you picked up and appear for them. Do you have any questions at all?
No, sir.
Okay, that's all I got for you. All right, we'll send it over to you shortly. All right, Addison Flake. Do you want to come forward? How are you?
Good, how are you?
I'm doing good, thank you. All right, could you state your full name, please?
Addison K. Flake.
Thank you. All right, the state is alleging 2 felony allegations against you. One is theft of a credit card. The second charge is fraudulent use of a credit card. On those charges, you have the right to remain silent, right to counsel, and right to trial. I've scheduled you for a preliminary hearing that is on August 3rd at 4:00 p.m. A preliminary hearing is to determine if there is probable cause to charge you with these, not convict you. If probable cause is found, then your case will bind over to the Gila County Superior Court. They're right next door to us. If there's not probable cause, then the case could dismiss. There's also the possibility that the case could go in front of a grand jury prior to your court date. If that happens, you'll be notified by mail to that address that you do not need to appear in court.
Okay.
The best thing to do is to call a business day ahead of time
Okay.
before you make the travel to come to court to
Okay.
see if it's still proceeding.
Okay. The address actually might change within like the next week or so.
Okay, so then just, I'm gonna get to your release conditions here in a moment.
Okay.
In those release conditions, it's gonna say to make sure that you report any change of address to the court.
Okay.
So if you move or something, just you're required to make those reportings to the court.
Yes,
Okay?
sir.
All right. I'll review those release conditions with you now. Obey all orders of the court. Do not commit any crimes. Notify the court immediately of any address change. Do not leave the state of Arizona unless you receive permission from this court.
Yes, sir.
Do not contact the alleged victims in any manner. That's
Yes,
not
sir.
forever. This is while this is going through court. Do you understand those release conditions?
Yes, sir.
Can you comply with those?
Yes, sir.
And you'll appear in court unless you're otherwise notified?
Yes, sir.
Okay, don't forget to call ahead of time.
Okay. And you said August 3rd, correct?
Yeah, I'm gonna give you a copy, but it's
Okay.
August 3rd at 4:00 p.m.
Okay. Thank you,
All
sir.
right, I'll release you on your own recognizance. I just
Okay.
need a signature from you here where it says defendant. And you saw that you have family members in the courtroom,
Yes, sir.
so they hear and are aware of what's taking place.
Sorry, it's not going to be very pretty.
We're used to the bracelet signature. Can I have you run a couple of copies?
I do have one question for you.
Okay.
Am I allowed to put a restraining order on Mr. Egbert?
You're allowed to get a restraining order on anybody you feel necessary to, and
Okay.
it has to just have cause and reason.
Okay.
You can do that through this court or any other court.
Okay.
So,
Thank you, sir.
thank you. Any other questions?
No, sir.
Okay, you're all set to go then.
Thank you, sir.
And then we're just right across the street and should be eligible to be picked up here in a few minutes.
Thank you so
Okay,
much,
you
Judge.
bet.
45? Okay.